Good morning, this is your Kelso Report for Friday, October 7th, and I'm your host, Clark Kelso. As Oscar Wilde famously learned the hard way, it sometimes is best not to challenge a derogatory statement about yourself by filing an action for libel. The results of the lawsuit can be worse than the statements themselves. In University versus Korean Broadcasting System, the university repeated Oscar Wilde's mistake. The Korean Broadcasting System ran a story about the university which asserted that it was a, quote, suspected degree factory, close quote. Reporters from KBS visited the university in Compton, but found no students, teachers, and no officials, except a signboard that is the only indication showing that this is a university. The reporters called the university a, quote, ghost school, close quote. When they examined some of the doctoral theses that were supposed to have been approved by the university, they found that some of them were identical to each other, and others were of extremely poor quality. The university sued KBS for libel, fraud, negligent misrepresentation, and intentional infliction of emotional distress. KBS demurred and filed a cross-complaint against the university's founder for libel. The trial court dismissed everything but the libel claims, and then held a bifurcated bench trial on the existence of libel as a matter of law on both the complaint and cross-complaint. The court found in KBS's favor. It held that some of the statements in the news report were nothing more than hyperbolic speech to describe the fact that no students, teachers, or administrators were there when the reporters visited. The court treated those statements as protected opinions. As for the factual statements regarding the dissertations, the court found those statements to be substantially true. On appeal, the university tried to mount a spirited defense of its institutional legitimacy and expressed outrage that its legitimacy had been impugned by the news report. But to no avail. The Second District affirmed the district court. It held that the allegedly libelous statements in the news account, when considered in the totality of the context and in light of the audience, was nothing more than statements of opinion, which were actually supported by underlying facts. Statements of opinion are, of course, constitutionally protected, so the court affirmed the judgment in favor of the reporters and against the university. Having suffered one defeat at the hands of the reporters, the university has now suffered two additional losses in court, once at the trial court and once on appeal. One hopes that 3 strikes is enough for the university. We have 3 one-liners, first in the area of criminal sentencing and probation. In People v. Quiroz, the 4th District upheld the constitutionality and statutory basis for a probation condition requiring the defendant to submit a record of income and expenditures to the probation officer as directed. The defendant argued on appeal that the provision was somehow unconstitutionally vague, but was never able to articulate how the condition was vague. It seemed perfectly clear to the court. The defendant also claimed the condition to report on expenditures was not authorized by statute because Penal Code Section 1203.1d expressly provides that a court may require the probationer to go to work and report income to the probation officer, but it does not indicate the court may order reporting of expenditures. Well, the court held that the catch-all provision in 1203.1, that is subdivision J, which provides that the court may impose other reasonable conditions as it may determine a fitting and proper, that provided the statutory authority for the condition. Our next case involves contracts and liquidated damages in Greg Opinski Construction v. City of Oakdale. The court affirmed a judgment in favor of the city, awarding the city some $54,000 in liquidated damages for late completion. The contractor argued that the city was at fault for the delay, but the trial court held that the city's fault was not properly an issue because the contractor had failed to request an extension of time through the procedures set forth in the contract. The 5th District affirmed, noting that Civil Code Section 1511 specifically provides that a party intending to avoid the effect of its failure to perform by asserting that the other party's act caused the failure must give timely written notice of this intention within a reasonable time, which the contractor had conceitedly not done using the procedures set forth in the contract. And finally, we have a title insurance case in Dollinger De Anza Associates versus Chicago Title Insurance. The 6th District held that a claim for breach of a title insurance policy failed as a matter of law because the government action, which impaired marketability of part of the property, did not have any impact upon the title or marketability of title to the whole property. In particular, prior to the plaintiff's purchase of 7 contiguous parcels, the city had attempted to issue a notice of merger of the 7 parcels into one parcel. The notice of merger was not picked up by the title company's search. When the plaintiff tried to sell the 7th parcel, only then did the purchaser discover the notice of merger, which caused the purchaser to back out of the purchase of parcel 7, which was to be a multi-million-dollar deal. The problem for the plaintiff was that the notice of merger did not affect the title to the parcels or their marketability. So the title insurance policy was not breached when the title insurance company rejected the plaintiff's claim. To sell parcel 7, the plaintiff will now have to go through appropriate local land use procedures to subdivide the property for sale. Best of luck to the plaintiff on doing that. And that's it for today's Kelso Report. Have a great day in the law.